Hello, I'm Lynda Hong, Assistant Podcast Editor for the Straits Times. In this episode of In Your Opinion, I'm joined by a lawyer with over 2 decades of employment law. Jonathan Yuen, partner from Rajah Tann. Welcome to the show.
Hi, thanks for having me.
Now, Jonathan, we're going to talk about how the upcoming Workplace Fairness Act will change the rules of the game for everyday workers who are currently facing disguised retrenchments. Let's start with the basics so everyone is on the same page. A regular retrenchment is defined as a dismissal on the grounds of reorganizing the company, such that the employee's role becomes redundant and the position will no longer be filled. This covers permanent employees and even contract workers with full contract terms of at least 6 months. But a disguised retrenchment is a staff member is laid off, but the employer deliberately misclassifies the dismissal to avoid paying severance packages. Now, how can employees tell if they were let go under the guise of retrenchment?
Right, okay, Lynda. So that's a mouthful, and let's kind of peel the onion slowly. Let's start off first with, I think, definitions, which I think are very important. So a standard retrenchment exercise occurs when businesses recalibrate and reorganize, and that's quite normal in a fast-paced business world. And this generally happens when, especially MNCs, they move offices from, let's say, Singapore, they move it to Hong Kong or Vietnam, or manufacturing companies, they do that, and suddenly a line of a production line that existed in Singapore for 20 years has been shifted to Vietnam or Batam or a lower cost area, and all these factory workers no longer have a job. Similarly, when a regional office decides, for example, to move, let's say, its entire regional office, let's say for cost concerns, out of Singapore and to locate it in Bangkok or Kuala Lumpur, then all the people that had regional roles will no longer have that, and that's the classic definition of restructuring or reorganization. Now, in these scenarios, most companies are, and especially MNCs, are already aware of their obligations, and most of them will have contractual benefits for their employees to pay some measure of a retrenchment benefit to them, calibrated according to their company's norms. I would say American, European companies tend to have these enshrined in contract. The problem happens, and I think the root of the issue here today is that for companies that don't have such contractual protections, what is the general state of the law in relation to what retrenchment protections workers get? When the company suddenly says, okay, so-and-so, you have been retrenched. And that is I would say, a very traumatic time for the employee. They're like, is it my performance? Is it the role? And I think this issue of disguised retrenchment, and that's where the conversation is leading to, pops up because then people want to understand why. And if you say that, there is a retrenchment, then why am I not getting something? And there is this expectation. So I think we'll talk a lot more about expectations versus reality. And I'll just kind of preface this by saying that it's a bit of a sobering reality for under Singapore law, because, and I'll just come out and say it first, retrenchment benefits are not legally mandated by law. The MOM has come out to say it. In a recent court case at the Employment Claims Tribunal, ECT3, the court has also made clear that retrenchment benefits are not legally enshrined in the Employment Act. So it has to be in your contract. And there's no standalone cover-all kind of magical retrenchment benefits that are payable. So a lot of times when people kind of toss around things like, oh, if you've been retrenched, you ought to get 2 weeks to 4 weeks for every year that you've worked with the company. What these people are referring to in such conversations are MOM customary norms that the MOM suggests. So the word is suggests, and I always very cheekily say that MOM can strongly suggest, like an Asian parent strongly suggests. But at the end of the day, if the company says no, we're not going to do so, it's not that it doesn't create an independent legal right for the employee to then go and sue the company in court and say, well, I've worked for you for 4 years. Where's my 4 months retrenchment benefit? Because I'm entitled at law to it. And the short answer is that no, you are not entitled at law to a standalone retrenchment benefit. And I think that is the crux of the issue here today.
So is that the reason why we are seeing fewer than 10 employee complaints made every year? Because when we look at the official numbers, from 2021 to 2025, disguised retrenchments, there were only fewer than 10 complaints made every year. And this is less than 1% of total complaints received each year, right? So it doesn't look like a lot. But with retrenchment increasing this year, do you think that this is actually an underreported statistic?
Yes, I think it's probably, and I speak only from anecdotal experience. I think most times workers and companies will somehow come to an unhappy compromise somewhere, and there will be, some form of payment, something, maybe not as much as the employee wants, but perhaps better than nothing at all. And then it doesn't get reported. I think the cases that get reported are those where I think the company, for whatever reason, and we don't want to prejudge the circumstances, solidly refuse to make any payment at all. Okay. And I suppose that also is after the unions step in and they try to negotiate something better. Not all companies have a collective agreement. Some companies don't have that, but the unions still try to come in to help. I mean, that's a different story altogether. But ultimately, I think some kind of a compromise is made between parties. So I think that speaks to why this is not a higher reported number, perhaps, but that's just my personal view.
But do you think that there's the use of NDAs or private settlements that's hiding this uglier reality?
Well, yes. The short answer is yes. And I think that, for example, when we act and advise companies, if an employee brings a claim, and it can be for anything, right? Not just for disguised retrenchment. It could be a failed performance improvement plan. It could be a potential wrongful termination, for example. Companies in general don't want things to explode all over the newspapers or in the High Court. And so what will happen a lot of times is, even though the company has a good arguable case against the employee, they're still prepared to make some form of settlement to the employee, but on the understanding that the employee then signs a non-disclosure agreement and a full waiver and release of all liability against the company. The employee also can't have it both ways. And so again, right, we come to this what I call a unhappy but livable compromise that both sides can accept. And both sides go along their own ways, and this is not publicized. So I think that also speaks to why not many of these cases will escalate all the way up to a court of law, to the point where a high court judge writes or the ECT tribunal writes a judgment to speak about these things in the open.
So speaking of payouts for those retrenched, and you've also mentioned a lot just now about the fact that employment or retrenchment benefits are not as part of the current law. Those working in unionized companies can expect 1 month of salary for each year of service, capped at 25 years, and they should have but NTUC Assistant Secretary General Patrick Tay noted in February's Parliament sitting that some MNCs were capping retrenchment benefits at 12 to 15 years of service, which is far below the 25 years commonly provided in Singapore. How strong are the national guidelines, the tripartite advisory on managing excess power, in actually getting employers to stick to this norm?
Okay, so let me just deal with that on the two issues that are intertwined in your question. The first is the effect of a collective agreement. And obviously, a collective agreement is something that's mutually negotiated between the company and the union. And that will usually set out how and in what manner and what form and retrenchment benefits will be paid to unionized workers. So for workers who are unionized and you're listening into this show, if anything at all, please go to your union rep, pull out your collective agreement. Your rights will be enshrined in the CA. And that's the starting point. And if it says, 2 weeks for every year or 1.75, months for every year or whatever that has been agreed between your union and the company, that is what you'll be getting. Okay. Many times, CAs also, as a form of compromise between the union and the company, also independently cap payouts. So we have seen CAs, and we have helped negotiate CAs that have kept the maximum payout a lot lower as well. So there is no, I want to kind of gently push back against the idea that there's some kind of a national standard of 20 months or 12 months or 25 months or 30 months, as it were, because it really depends on the commercial negotiation outcome between the union and the company. Now, the other bucket that we then turn our attention to will be how effective, and this I think is the elephant in the room, how effective are the MOM guidelines in respect of retrenchment payments. So we always tell clients this, and I know that Patrick will be listening at some point in time, so I don't want to get an angry text from him. But we always tell our clients who come to Rajah Tann, we say, please comply with these guidelines. And we say this with a little dry humor. It's kind of like, when your Asian mom says, I'm strongly encouraging you to clean your room, then you'd better listen to what your mom says. Literally, mom, your MOM. Anyway, bad joke. But most companies understand that if they want to operate in Singapore, they have to comply with these customary norms, and I'm happy to say that most companies do. The only time when companies really cannot pay retrenchments, and I think the MOM also understands that, is if they are going through true financial difficulties. Like they have to retrench workers because the company is no longer solvent. Right, I mean they've collapsed. They've been, and the judicial manager takes over, and they just can't pay anything anymore. But barring that, I would say most companies will work with the MOM, understanding that these guidelines are not strictly law, but that the MOM expects compliance with them as a supplement to the law. And I think that's how the tripartite system works. I think everyone has to give a little, has to work with a little bit of a give and take. I want to just kind of pause here and I suppose address some of our listeners who may have a more Anglo-Saxon approach to dispute resolution, which is to say that our Singapore government has distinctly chosen this tripartite model for a lot of side kopi chats between the stakeholders, SNEF, the unions, and the MOM, and to resolve things by dialogue, mediation, and negotiation rather than the adversarial system that you see in the West. Now, this is not an indictment on the adversarial system. It's just a different approach to dispute resolution. And that is why, for example, in the Industrial Relations Act, there's always a mention of conciliation. And it's a very nice word. It's a loaded word. But it basically means that if the company and the employees or the union really can't work it out between themselves, then MOM will invite both sides to come and lim kopi and sit down and say, okay, guys, let's sit down and let's see how we can work out the situation. And it's not strictly legal, Lynda. It's a process that's provided for in legislation, but the entire discussion is all behind closed doors. There are no records. There's no court judgment of who said what during this, and that's to preserve the privacy and the sanctity of this blame-free environment, without prejudice environment, where parties can actually try to problem solve rather than attack each other.
So you've been in one of these conversations before. in your years of experience, I assume.
Yes.
Okay.
Although I will also dryly joke and say that for many times the lawyers are seated in a different room because having lawyers represent the company in such meetings can usually be quite inflammatory. We don't want to be there. We're always nearby and reachable by our clients so that we can work with them and advise them as the negotiations progress. But we don't speak for our clients. We don't, we don't sit in the room. We don't face the unions face to face rather. But we're just in the next room, we linger in their earpieces of our clients and we're just a phone call away.
Okay. And if retrenchment benefits aren't mandated by law anyway, why do companies still go through the trouble of disguising a layoff as a performance issue? You've also mentioned just now about failed performance issue. What does that mean?
Right. So I'll answer your first question. And the short answer is I don't know why companies go through that effort. I mean, companies who come to us and say, hey, look, we have this issue where we need to downsize. And then our starting point will be, well, then let's just look at what the contractual issues are. How do we look after the employees that you have earmarked for departure? We want to make sure that the selection of these employees is fair, that there's a consistent objective standard applied, whether it's first in, first out, or last in, first out, or is the company going to select, for example, the bottom 15% performers over the last 3 years averaging, right? And then the company says, then we will separate from these people. And we also spend a lot of time talking to our clients about why are you doing this? Because the MOM also has these guidelines and frameworks to remind companies that retrenchment should be a last resort, a measure of last resort. And what the MOM usually says is, look, there's an Annex B. Go and look through it. These are the pre-retrenchment checklist. So basically, we would sit down and we'll work with the company through it to basically say, look, have you shown good faith in, for example, attempting to reskill someone, retrain someone, redeploy someone? Can this job scope be saved somehow by maybe this person coming in 3 times a week instead of 5? So these are serious conversations, and then we need to ask the company, strategically, why are you doing this? Why did you come to us and say, hey, we want to exit, 45 people, Rajah Tann, help us do it. And the starting point would be, okay, let's start off with the why, and then we'll work through the how. And a lot of times we also want to bring in the unions early, and we want to bring them in as partners and collaborators. And I think this is just human nature. A lot of companies don't want to talk to the unions and they want to hold it off as long as possible. And we tell them that that's generally not the right approach, because if you hold the unions off at bay for as long as possible and then you dump your perceived solution on their laps and say, dear union, we have thought about this for the last 16 months and blah, 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 blah. Here's our great plan that we've worked with the lawyers and we've come up with this wonderful thing. Now we just want you to sign off. And then unions are going to say, sorry, this is not going to be a fair comply. I'm not just going to sign off on it. And I want to go back into your reasoning. And then you've just wasted, 8 months, 10 months doing this. I would also say that, most times my general experience has been that unions, while they push quite aggressively, most of them I think they're quite commercial. They understand that ultimately, and this is the caveat, when they have been involved at an earlier juncture, they generally understand that a lot of retrenchments are in good faith and commercial. So they work with us, with the company, to make sure that there's a softer landing for the employees who have to depart.
And what about the failed performance improvement plan, or PIP? How does people come to go to lawyers or complain, make official complaints? What happened? What are some of the instances you have come across?
Yeah, so it's very strange, because if you were HR, CHRO, or HR director, or listening into this and you're thinking, what is the most efficient way of putting it crudely, what's the most efficient way of trimming my headcount and getting rid of some people? In no world would I say hey, CHRO, please use a performance improvement plan to counsel someone out, because a performance improvement plan is just ripe for attacking by the employee. Imagine the employer says, hey, Lynda, you're not doing well. And then the employee says, I respectfully disagree. I angrily disagree. You haven't done these things. I disagree. I have. And then it becomes this back and forth, which is not helpful. So the only way that employers can really protect themselves to exit someone through a performance improvement plan is to make sure that they document everything. And even if they document everything, in today's highly litigious environment, employees will fight back on every single point. So I don't understand why, and this is of course my personal opinion, and that companies would even attempt to use a PIP to disguise a retrenchment, as it were, to exit someone. A much more straightforward method would just be to say, you know what, this role no longer exists, and let's negotiate a landing for you.
There's also some scenarios that we've heard of before, that people were called into a room by HR out of the blue, handed a separation package, and then they were told you have 24 hours to sign it or face dismissal with nothing. If that worker in the room realizes that retrenchment benefits aren't even guaranteed in their contract and they're not part of the union, what leverage would they have to actually walk out, seek counsel, and negotiate a better package?
Yeah, that's a tough one, Lynda, because currently there's no law that stipulates how long a person ought to be given. I mean, I'll just give a very narrow example. Some of our clients, financial institutions, hedge funds, they work on a very tight turnaround, and an offer given to maybe a high-performing portfolio manager is maybe only open for 4 hours, and they'll say, hey, we no longer need you, but if you sign on the dotted line here and basically agree not to sue the company or blame us for anything, we're going to give you a chunk of change. And this comes with all the disclaimers and essentially legal releases and waivers, but you have to sign this in the next 4 hours. There may be some whinging, there may be some complaining, but I think money talks, and a lot of people are prepared to say, you know what, if you ply me with enough money, I'll just sign it. It's not worth the hassle. That is the margin and extreme case, because I think for very high income earners who are put in that situation, I think the rest of society will say you have the world's smallest violin. I think the issue will become, or is, that the issue is for the vast majority rank and file workers, the ones that earn the medium income, and they are given what appears to be a very, very short time to make a decision, and there isn't even enough time to run off to go and even hire a lawyer to look at it. I don't have a ready answer for that. And the reason is because until and unless the law is changed to stipulate that there has to be some kind of a cooling off period, a minimum of, 3 days, how companies generally work around it and how we advise our clients, and this is of course only very anecdotally how we advise our clients, is that we would tell our clients generally to give anywhere between 2 days to 4 working days for the employee to read through the terms and then to come back with any questions and things like that. Most times when the separation is on a good leaver basis, there's generally a lot of goodwill. And both sides are saying, hey, departing employee, here are your separation agreement terms. Come back to us in 2 days if you have any questions. But we would like to get this closed by the end of this week. And that's the general tenure of how the conversation will go. In a contentious and a dispute scenario, when both sides are represented by lawyers and then angry letters have been written back and forth already, the company may say, you know what? This is our final offer on a without prejudice document. You have 48 hours, take it or leave it. If not, we'll carry on the trial and see you in court. And in those instances, I think given that the ex-employee or the claimant employee is represented in themselves, I think it's a fair, it's fair because you want to get in the boxing ring, then don't complain that you're punched in the face. in that specific scenario, 48 hours or sometimes even less is not unusual.
And we talked about the law changing, and it sounds like the rules of the game need to change, and they are about to. The Workplace Fairness Act was passed in late 2025 and will come into effect in 2027. And this gives companies time to adjust their HR policies and internal grievance frameworks before the law becomes legally enforceable. So this law also essentially turns the tripartite guidelines on fair employment practices into binding law, right?
Yes, parts of it.
Yeah.
That's right.
So for the everyday worker who feels that they are being unfairly managed out, what is the biggest, most practical change this law brings to the table?
I think the issue is documentation and processes. And from a departing employee standpoint, it's going to be quite emotional, and they are probably going to disagree with what the company asserts to be the reason for their departure. So, and this is what we have been telling all our clients, and we've been saying it ad nauseum. MOM has been going out on roadshows and telling everyone to please get ready all your processes. The key here is documentation, documentation, documentation. This lead up to the end of 2027, when the Workplace Fairness Act comes into effect, is a grace period for companies now to get their processes ready. So, for example, in a retrenchment, if this escalates into a dispute, which and I'm going to preempt your question, yes, we anticipate that there will be a significant spike in claims against companies. The companies need to be prepared and to basically say, okay, we have this retrenchment exercise, we can substantiate it, it's not a fake one. And the reason why you were selected was because, and to explain, right, there is a plan. This is not a mad culling of people, of someone walking around and saying something absurd like, find all the most expensive headcounts and fire them tomorrow. It's more like, okay, we have decided that we are going to be trimming, let's say, Department A, because we're shifting Department A to Kuala Lumpur. And so, because the whole Department A is going to be moved out, we're going to be exiting everyone in Department A. So there's a basis, there's a logic, and there's an objective framework applied to this. The Workplace Fairness Act has this issue on protected characteristics and discrimination, and it'll be very, very interesting. That's a loaded term I've used. Very interesting to see how these protected characteristics will play out in a retrenchment, because the employee will say, you've discriminated against me. I have a mental health issue and you purposely picked me. And you've discriminated against me because of my health issue. And the company will probably say, no, I didn't. It's because you were performing well. Oh, you were not performing well, as the case may be. And the employee will say, I was not performing well. First of all, I deny that I was not performing well. But any non-performance was because I have this mental issue, which perhaps then the employee will load it up even more and say, which was caused by my workplace to begin with. So you can see, Lynda, it can get very contentious very quickly. And so if companies are going to be selecting people for retrenchment, people for performance improvement, I say the three magic words again: documentation, documentation, documentation.
So in terms of documentation, right, for disguised retrenchments, how would this new act weed out disguised retrenchments? What kind of documentations do you foresee that is needed?
I think and let's talk about clean hygiene from the company side, right? The clean hygiene. The company must be able to justify that it has taken the decision to retrench only after going through all the other pre-retrenchment steps and have decided that there's no choice but to retrench. Then the next large bucket question to answer is, then why this employee? Meaning, why employee A and not employee B, or employee C or D for that matter? Or why employees A and B and not C and D? And again, the documentation hygiene ought to be there to explain to them, or the MOM, or to answer to a lawsuit, why these people were chosen. Were they unfairly targeted because they had a protected characteristics. For example, some one says, "Oh, let's target all the pregnant women because we don't want to pay, their maternity benefits," and this kind of obnoxious behavior. And I think on the ground, people are not stupid. If they see who is being let go, and they see that it's not a form or function thing, then they're going to start questioning, why are these people chosen? And we always work with clients to say, let's craft your media message properly, your external comms properly. And the more you share, the more candid the way you share, and the easier the journey will be. I just want to kind of bookend this comment by talking about how Cheng Kai-Fong at the GovTech recently did this exercise. It was a very candid one. I especially enjoyed the fact and appreciated the fact that he said, we're very sorry that this is happening, and I want you to hear it from me in person. It helps when senior management is on the ground for the town hall. It also helps when they admit that they don't have all the answers either, but we are working through it together, and we will work through this together. And I think that is kind of message that people appreciate. What people don't appreciate is they find out that person A has been let go, person B has been let go, and then suddenly they log in and then they've been locked out of the system, and then suddenly no one's answering their emails. And that just, I think, adds to the trauma. And when people are faced with trauma and uncertainty, I guarantee you, in my 20 plus years of practice, it will always manifest itself into anger. And then that will end up becoming a complaint to the MOM, to TAFEP, to the union, or straight out a lawsuit. And I think companies can save themselves a lot of heartache and grief if they do this with a bit of common sense, in compliance with MOM regulations, and a little bit of compassion.
Just now, you also mentioned that one of the most difficult form of discrimination was mental health.
Yeah.
How would you advise companies, or how have you been advising companies to protect themselves, or to even set up a structure so that there will not be such a spike of employees dragging their former employers to court?
Well, I think this conversation has to be a two-way conversation between the employer and the employee. We have seen cases on both sides. We've seen cases where employees have genuine mental health issues, and they come in and they discuss this in a candid, open manner with legal compliance and HR. And the company, to the extent possible, makes accommodations for them, to maybe remove them from certain streams of workflow that may trigger their anxiety, their depression, for example. Unfortunately, I must also share with the listeners that we have also been engaged by companies to deal with people who sully the entire mental health issue by alleging or asserting mental health issues as a sword against the company, and using it to make all sorts of absurd demands. And I think those people are doing a huge disservice, because they are causing companies to react more defensively, more aggressively, and more legalistically to such mental health demands, or rather mental health issues. One way that we commonly encourage clients to de-escalate the situation is to go for mediation. And we also suggest to have a second opinion on the mental condition in question. And I think having a second opinion, or sometimes even a third opinion, I think realigns expectations for everybody. Sometimes you have suspicious HR people who say, surely that cannot be the case. But when the second psychiatrist says, no, really, this is the case, right? I went to med school. You didn't. Trust me, this is a mental health issue. Then the companies will say, okay, I accept it, right? And then they learn to separate the people from the problem. But I think the employees, and I want to say this to people who are thinking, I'm going to use this against the company. Please don't. I think it's doing a disservice to people who have real mental health conditions. And And if you have such an issue, I think open, candid dialogue, if you need to be guided by solicitors, so be it. But I think both sides need to meet halfway for this to work. And it's very early days, Lynda, because we don't know how this will be adjudicated by the courts. I'm pretty sure that sooner rather than later, there will be a lawsuit that will go out to the ECT in relation to discrimination on the basis of a mental health issue, and we'll see how the courts will interpret the parameters and the four corners of the boxing ring, as it were.
And when the new act comes into effect, the Employment Claims Tribunals will be able to hear discrimination claims, and you're saying that mental health would actually be be a massive contribution to the spike?
Yeah, so yes to your first question, the ECT will be empowered to hear claims under the Workplace Fairness Act in relation to discrimination. Yes to your second question, that mental health is a protected characteristic. And I would say this personally, I think also yes to your question that I expect to see a spike in these claims until at least some guidance is provided by the courts in Singapore as to what the limits as to how these things will be adjudicated, and then that will have some kind of a stabilizing effect. And I think everyone is kind of looking at to see how that will play out. I think it'll be some time, but I think MOM will be releasing some guidance as we lead up to 2027 as to how they expect this to play out. And I think this type of guidance from MOM is always very, very useful in managing expectations, both on the employee as well as the employer side.
And with the new act coming into force, the burden of proof is shifting for the professionals, managers, and executives of PMEs who are listening right now, who suspect that their company is quietly trying to edge them out. What kind of paper trail do you advise them to start documenting today to protect them under the new laws?
All right, so let's start off by answering the first question, which is the burden of proof. The burden of proof solidly still remains on the claimant. So they have to prove their case. Okay. The only time when the burden shifts to the employer is if the employer purports to dismiss an employee for conduct of a performance. So they say, we're terminating you for cause because you've been a bad person, you've done something wrong, and we're going to terminate you for doing something dishonesty, or you've done stealing from the company or exfiltrating confidential information. We fire you on the spot today. If the company goes down that route, they have to prove it, and they bear the legal and factual responsibility of proving it. But if somebody wants to say, I was wrongfully terminated, or I was discriminated and I was wrongfully selected for retrenchment because of my condition as a pregnant mother, for example, or that I'm old, right? Then that burden falls onto the claimant. So I just want to make sure that our listeners understand this. The Workplace Fairness Act doesn't magically give claimants superpowers that they don't have to prove their case.
In fact, if they actually lose this case, they might actually have to pay for all the lawyer fees as well, right?
Well, there will be a provision for costs to be awarded against claimants if they lose, but that's par for the course as well, Lynda. And again, I just want to make clear to our listeners today that is the same thing when you step into court in any event. The rules of court already clearly provide, to put it simply, the loser pays. Now, what the loser exactly pays, that's a different conversation altogether. The court has a schedule of fees that the courts will say, roughly for this type of claim, for this type of complexity, even if you lose, the standard fees to be paid is X, and the court will set that out. I suspect that even if claimants lose in the new ECT claims for discrimination, I suspect that unless the claim is brought in bad faith and the claimant has acted in a really obnoxious, terrible way, wasting the court's time, I suspect that the courts are going to be quite conservative in awarding costs. I don't think costs will be used as a way to penalize or chill the ability of a claimant employee to bring a claim. It's not meant to be a punitive measure. So you're right, the loser will have to pay, but I don't think it's going to be something crippling either. The trade-off is that the disgruntled employee will have their day in court against their employers. And I think what employers are most concerned about is that in a discrimination claim, the jurisdiction of the ECT has jumped up to $250,000, and the company cannot engage lawyers to act for them. So this means that the company will have to send its in-house counsel, its head of HR, or somebody to face this employee at the ECT before the ECT judge. And so the whole point of this is to level the playing field, as it were, to make sure that lawyers are not introduced into the mix. I have my personal thoughts about that. I think that, and I speak personally, I think that for normal ECT claims for salary or for wrongful dismissal, which are still capped at $20,000 or $30,000, I think that's fine. It's a very socially efficient way to clear the backlog. But I think, and again, I want to say that this is something I've spoken about before, and I want to make sure that this is my personal view. When a claim for wrongful for discrimination has to be adjudicated on, and the jurisdictional limit is $250,000, that is the entire jurisdiction of the state courts, all the way up to the edge of a high court claim in the high court. And discrimination claims are not simple. These are complex matters of law and fact. And I'm not entirely sure how a claimant and an in-house person, HR person who is not legally trained, or even a in-house counsel who handles, general legal work, has to suddenly run a full-blown state court's trial with rules of evidence, civil procedure, witness statements, cross-examination. I think that is to me something that bears relooking again. The absence of lawyers from this process.
So we will actually have to await for what the Ministry of Manpower actually has to come up with.
Yeah, so we're waiting for two
course.
things with bated breath. And I always joke not to put too much pressure on our MOM friends, but hey, the whole Singapore is just waiting to see what their guidance principles are in relation to what they see the parameters of the claims and how these claims ought to be adjudicated and what types of claims fall here. And in many public forums, we've had very, very useful MOM feedback. They do these road shows. A shout out to my friend Sarah Sim from MOM, and she's been great. Patrick has been great to explain. Like MOM will in the months ahead put out some FAQs, put up some illustrations to the public to illustrate what are the classic cases that ought to be captured. So that's the first data point from MOM. The second data point will obviously be judgments from the court. And I think what's happening now is great. We are seeing a slew of written decisions from the Employment Claims Tribunal coming out. I think at last count, there have been 7 judgments coming out, everything from wrongful termination to payment of bonuses and things like that. And the more these cases come out into the open, then a body of law or jurisprudence will be built up, and people can start relying on that to say, this is how I should manage my dispute with my employee or employer.
Wow, okay. Jonathan Yuen, thank you for your insights.
Not at all. Thank you for having me.
You're listening to In Your Opinion, a podcast by the Straits Times. You can find links to other podcasts, opinion columns, and stories in our podcast show notes. This episode is edited by Hadil Rahim, and I'm Lynda Hong, signing off.